Good evening. You're watching The Digital Age, and I'm James Goodale. I've got a great show for you tonight. This show is about what do you do when something's posted on the net that's scurrilous about you and they won't take it down. That's to say, the people who run the website won't take it down. This happened to a couple of Yale Law School students. And guess what? They may never be able to get it down. Should Yale win and the web lose, or vice versa? Tonight, to discuss this question with us is Beth Simone Noveck from New York Law School, where she teaches intellectual property, and Michael Fertik of ReputationDefender, who is actually paying for this lawsuit. More about that in a minute. Beth, these Yale Law School students, what did this website say about them? Did they say that they were involved in a lesbian affair? Did they say they bribed their way into law school? Did they say they had low law school test scores? Did they say they had herpes? Is this what happened?
That, I'm afraid, and much, much worse. So on this website, AutoAdmit, a number of posters, as in people commenting on the website, not named individuals, but people using pseudonyms like the Ayatollah of Rock and Rolla and other similar kind of web handles, posted really, truly scurrilous comments about these women who at issue. So they posted comments that are arguably potentially libelous or defamatory, and that's what these women are interested in pursuing in court, namely is not only having their this information taken down about them, but hopefully seeking some redress against the harm that they've suffered. Because what's alleged here is that not only were these nasty, nasty comments posted about them, but they failed to obtain summer employment, that their careers have been harmed, that they've been psychologically and emotionally damaged as a result of these really nasty postings, and in fact that they feel physically threatened, not only in cyberspace, but in real space, as a result of what's been said about them on the web.
Let me ask you a question about the summer employment. Because when I talk to people about this case, they can't believe it's happened. There's a generational problem here, you may understand. Apparently, 50% of employers look at Google before they hire people. Is that really true?
Well, I don't know about the exact numbers. I'm sure Michael can tell us a little bit better. But if you were trying to decide whether or not to extend someone a hire, not just for a summer job, but to potentially what will turn out to be lifelong employment in your law firm. And don't forget, law firms' reputation, client confidentiality, client trust matters a great deal. You're going to do a background check. And today, rather than hire a private investigator to do that check for you, why not do the free version of that, which is take a quick look on Google, see what comes up about somebody, see what comes up on their Facebook page, their MySpace page, and their presence on the web. So what's happening is for students in particular in professional schools who are applying for jobs in reputable law firms, those firms may be very well taking a look on the web to see what they can find about these students. And in fact, what's coming up, sometimes not way down on the second or third or fourth page on Google, but right up front, are these nasty, nasty postings, these comments about them, true or untrue, but firms are reading them and potentially influencing their hiring decisions as a result.
So why are you paying for the suit?
Okay, so we're paying for the suit because nothing else yet has worked for these women.
What do you mean nothing else has worked? Do you send letters to, what do you do anyway?
So the first thing we do is
reputation. What did you do?
So when one of our clients has things about them they don't like on the web, with some exceptions, so we won't try it for a news article or for a government record, but if there's something that they don't like, the first thing we'll do is we'll try to just ask the person who has posted it or who owns the website to take it down, and often enough that'll do the trick, and if not, there's some mediation that we can do. It can become a quite involved process. If none of that works, and it's very rare, but if none of that works, we can refer the client to litigation, or in some cases, even pay for the litigation.
But I understand referring for it, but why are you paying for it?
Because if
you pay for it, it sounds to me as though there's a matter of principle involved, or it's not. So you raise $1 million, I understand, for your company. Is that right, from venture capitalists? You've raised some money for it anyway?
Yeah, raised some money, yeah.
Whatever the amount is. And you must be using, I would have thought, some of that money to pay for this lawsuit.
Yeah.
So try again on,
is it a matter of the lawsuit in this case?
Yeah, is it a matter of principle?
Yeah, there's a lot of principle here.
Oh, okay.
The women are suffering unfairly. There is law that should protect them, but does not in this case. The law is not adequate to the task of protecting them yet. And there's a kind of reckless abandon that appeared, or sometimes appears in different websites, that people sort of enjoy torturing other people. And they get nothing out of it other than the schadenfreude of seeing someone suffer and the enjoyment of torturing them. So it didn't sit well with me. It didn't sit well with me that this was going on, without any kind of consequence for the people who were doing it. And so I said, enough is enough. And so I said, put up or shut up. So we put up.
So they put up, and they sued the administrator of the website. Let's call it a website, just to make it easier. And one of those named person was a gentleman whose name is Cioli, I believe it. And he is the University of Pennsylvania law student who was running this thing. But he says, you can't sue me. It's my First Amendment right to run these sites, so go away. And by the way, he had a summer job and lost it for maybe taking the stand or for running it.
Yeah, but he might have a better book deal as a result of having lost that summer job. Now, he was originally one of the named defendants in the suit as the administrator of the website. As one of the administrators, not the owner, but one of the people running the website in this case. He was subsequently, of course, dropped from the suit, and I think rightly so. Because the issue here is not, I would say, whether the law protects these women. There is law that protects these women. There is, in fact, they are bringing a lawsuit against those people who have arguably spoken ill of them and caused them intentional infliction of emotional distress, who've riled them up and caused them this emotional pain and harm. The question is whether not the people who spoke badly of them, but the people who run the website, a third party who are providing the ability for other people to speak, should be held responsible in this case. And there I think Congress has spoken by enacting a law which says no, in cases like this where libel and defamation are potentially at issue, that the third party, in other words, the Googles of the world, the websites of the world, the Wikipedias of the world, should not be responsible for what other people post on those sites. It's simply a First Amendment right, and we want to allow people to speak freely on the net, even when sometimes that free speech causes other people harm.
Well, that's a nice First Amendment speech that we've just heard. But
well, it's a good essay of the law as it is today.
But I want to ask you, as a practical matter, does the nice theoretical approach that we've heard make any sense? For example, can I ask you whether, what did you say the gentleman was who was posted this, the Ayatollah of what?
The Ayatollah of rock and rolla.
No,
one of several.
Okay, Ayatollah of rock and rolla has been sued in this case. Harold Cole, the dean of law school, has been sued because someone's using his name. Right. Are the people who are, these two ladies, are they ever going to find out who the Ayatollah of Rock-a-Rolla really is, so they can get the redress?
They already know who one of them is. I don't know if it's that guy, but they already know who one of them is.
Well, there's 10.
Yeah, but it's easy. You get one of them, it's easy. They're not hardened criminals. They're going to turn on one another, I guess, is my guess. And that's a prediction. I mean, as soon as we entered this lawsuit, as soon as the lawsuit commenced, the nastiness of this site really dwindled, and in some cases entirely dried up. And there were efforts to, the people who were doing this sort of tried to cast blame on one another, and then after sort of standing on some kind of, behaving to some kind of bravura, some kind of machismo, they sort of retreated into themselves very quickly. But sort of as a broader matter, not just in respect to this case, the law that Beth accurately described was passed in 1996 when the internet was in its sort of mainstream infancy, okay? And Congress passed a law saying that if you write something on a website, then you may be liable for what's said on that website, but the website owner is not liable. And that made sense in 1996 because in 1996 there were basically two ways to get on the web. One was America Online, now called AOL, and the other was Prodigy, if you remember Prodigy, and there were some handful of others. So it made sense because if you were the perp, right, who was going on the website attacking Jim or Beth or Michael, Jim or Beth or Michael could subpoena AOL and find out who you were because AOL's got your username, your home address, your real name, your credit card information, all that stuff. Now the web has changed in the last 12 years, 10, 12 years. And so now you can sign up with a fake Hotmail account or Yahoo account that you can get instantaneously. Sign up with a fake username with that Hotmail account. So you become harder and harder to trace. So it's true, Congress does allow you to sue somebody, which means you have a right. but you can't find that somebody now,
let's talk
which
about
means you don't have a remedy, which means meaningfully you don't have a right. So this lawsuit is part of establishing the importance of having a remedy for that right.
Okay, well, let's come back to that because that's the main subject here tonight. But let's go back to the question of finding these people, because sometimes you can't find who the Ayatollah of rock and roll is, and why is that?
So let's be clear here for a second. I think the characterization is absolutely correct in that it's become harder potentially to find people. So you can't simply go to AOL and say, hey, AOL, hand over the name of who it might be. It doesn't mean, however, that a website operator can't be subpoenaed to turn over, even if they don't have a credit card or an identifiable name. They may have an internet address that can then be linked back not through the website operator, but through the internet service provider, the Verizons of the world that give you access to the net, that may be able to then give us access to the name of who that person is. You're right.
What if you can't? But what if you can't? And there's this horrible thing called Tor.
Oh, don't characterize Tor as a horrible thing.
No.
Tor.
In one sentence is?
Tor, in one sentence, is what we might term, in one word, we could call it an anonymizer, in the sense that it is a computer program that makes it easier for people, that makes it possible for people to communicate, to post things on the net anonymously. Now, Tor is, though, I don't want to characterize it, though, as easy. I don't know how to use it. I bet you don't know how to use it.
I downloaded it.
You got so far as downloading it. That's right. Did you use it?
No.
Right. Of course.
But here's the thing. I downloaded Tor, which for the audience is this system that hides forever who the Ayatollah of rock and roll is. And then I said to myself, my goodness, suppose that everyone in this lawsuit, all the Ayatollahs, had used Tor. And Tor says effectively you can never, once you use it, you can't find who the Ayatollah is. But so suppose, Beth, just for a moment, that you can't find out any of the anonymous names, which is certainly possible.
So let's take that situation for a moment. So you are right that let's stipulate that it's getting harder potentially to figure out who people are. There's an extra step, extra 2 steps, extra 3 steps. There may also be cases in which we can never find out who somebody is.
There we go.
But what we get in return is we get the ability for people to post, what Tor was invented for is for people to post political speech in repressive regimes like Iran and Saudi Arabia and elsewhere, to enable them to speak out politically, to respect their democratic and their free speech rights. What we get is, by having a law that protects against liability for the website operators, is we get a world in which courts are the ones who are deciding who is libelous, in which courts are deciding who's responsible, and not the website service operators. This Adam Scioli that you mentioned earlier, I don't want him deciding whether a statement about me or even about these Yale Law School students is defamatory or not, and himself exercising the judgment about whether or not to take something down. I want a court to be making that decision. Now, to be clear, and the website service provider, the person hosting the website, can take things down. It's a private operator. It's not the government. They can go ahead and take things down, and that's another issue.
You want them doing it only when they want to do it.
But I want them, what I don't want them doing is I don't want Congress putting a gun to the head of the service provider, a gun to the head of the website service operator, and saying, if you don't make decisions about what's libelous and what's not, we're going to impose liability on you, creating thereby an incentive for the website service operator, the auto-admits of the world, to go ahead and take down content and thereby potentially chill free speech for others.
But they should.
We have to go back a couple steps.
They should be taking down.
There was a lot there. There was a lot there. So
there's a lot to work with.
There's a lot there. So the first thing is that there is another way that you can remain anonymous. You can remain anonymous on the web, and that's for the website owner not to record your IP address. It just means not to record the computer from which you're visiting the site. If they decline to do that, then they are making a choice to encourage a certain kind of anonymous speech, which may be very desirable in some cases, and maybe in certain cases very undesirable.
Yeah, but it's not the kind of speech that we're talking about in Czechoslovakia when the Russians are invading, which is political speech.
In their case,
she's saying that's what the trade-off is.
In some cases it may be. In the cases that I see, chiefly it's not. In the cases that I see, it's chiefly about someone's being fat or photographs being...
fat would be fine, but how about a lesbian affair with the dean of Dean of Admissions of Yale Law School.
So let me carry on. So there is also another statute which informs this area, which is called the Digital Millennium Copyright Act. And it protects not privacy, but copyright. It was passed 2 years after the statute that we were just talking about. And it has a very simple regime for copyright protection.
You got to take it down.
Only after you've been notified that it's been owned by somebody else.
Would your view be that that's what we ought to have a chance? What do you think is the fairness of all this? Here you got got these 2 Yale Law students, as I said at the opening. It's entirely possible they may never be able to get this taken down.
What I think is that law illustrates that there are lots of ways to go about this problem. And if you're not liable until you've been put on notice that something is problematic for some reason, even if you impose on the person who's claiming that the duty of signing an affidavit and of committing perjury if they're lying, right? Even if you impose that liability on the person who's making the claim, then you have a different scenario, because now the owner of the website says, look, it's defensible. This person signed an affidavit or made a statement saying that he or she was willing to swear under perjury, penalty of perjury, that this comment was unfair or inappropriate or scurrilous or libelous or defamatory. And now I've taken it down. You release a lot of the pressure from these problems. This is one example of the very small steps that can be taken to alleviate a lot of the pressure. It doesn't have to be a situation in which the alternative to what we've got now is an internet without speech, right?
Why do we have an internet without speech? Let me ask Beth.
No, there is no. That's not the alternative.
I mean, but that's
it's not the alternative.
What Beth is saying, and this is for common sense purposes, see what Beth is saying. She's saying that we've got to have anonymous speakers. We've always had people who could shout out at the government and get away with it because that's important. But here we have people who aren't talking about the government, they're talking about Yale Law students. But Beth says, well, that's true, that may happen. But the trade-off, to use her word, is that we get all this speech on the internet, we get all these blogs, and that's worth it? Is that fair to say, Beth?
Look, we used to live in a world in which the infrastructure that was provided for us to speak, namely the sidewalks and the town squares and the town halls, was provided by the government, right? This was public land. And so the Constitution speaks to, and our law primarily speaks to, a world in which we fear censorship from the government. And so we have all kinds of protections against letting the government preventing us from speaking, which is why we have a right to talk in the town square and on the sidewalk. In this day and age, how many of us are going, do we still have sidewalks even? We barely get out of our cars. We don't have town squares anymore. Where are we talking? We're talking on the net, and that's where we're talking to each other. It's where we're blogging. It's where we're talking not just about politics, but about culture, about sports, about all the things that matter to us in a democracy. Who controls those sidewalks? Those sidewalks are controlled by private parties. They're controlled by websites like AutoAdmit. They're controlled by the internet service providers like Verizon that give us access to the internet. And so what this law does is it gives us some protection, as we've always had, to allow for people to talk, and to talk in ways that may not just be, yes, screaming against the Russian tanks in Czechoslovakia, but may speak in a way that offends people, that hurts people, that may in fact insult people. There is a difference, though, between speech in which I may say, I don't like your suit. You may be offended by that, but it's definitely not libelous. I do love your suit, by the way, but since we're on television. But I want to make clear that whereas you may be offended, that would not be a reason to have you run to Verizon and say, take down that posting. Or take down the comment that somebody may make on YouTube after this program is aired saying, I didn't like Noveck's jacket or her suit that she was wearing.
See, the problem, I understand your point. The problem with this
what we want to do is protect against the problem of private censorship in the same way that we've always protected against public censorship.
But there's no such thing as private censorship. I mean, the law has never recognized private censorship. The Constitution has never recognized private censorship. The law as it stands today is the radical change, right? Anonymous speech should be protected, political speech should be protected, free speech should be protected, opinion should be protected. But right now we have a situation in which privately owned websites enjoy more protection than a newspaper, right? Than media. And so the same statement published in Newsweek or the New York Times could render those institutions liable for the comments published in them, whereas on a website they would not be. So there's no real reason. I was on a panel with a professor in this field, very liberal guy, known as a critical legal studies guy, a liberal guy, who said, look, I don't see why the sort of the standard duty of care, the standard tort law should not apply here. If you have been operating your website for profit, by the way, for profit, so the more lascivious content that appears there, the more eyeballs you're going to get. So you want to encourage the profit and the profit lasciviousness, okay? Profit-making lasciviousness. If you're operating it with a kind of gross negligence, and you're operating it, with a kind of gross negligence, in the same way that if you're operating a supermarket and you allow milk to lie on the floor and someone slips and falls and hurts themselves, if you're operating it in a grossly negligent way, why should you not be liable for the content that appears? It's not to say that the content needs to be censored in advance or restrained in advance, but if there's no reason for common law principles which predate the Constitution, which certainly predate the internet, should not apply there the way they apply to every other feature of our lives.
Isn't this guy, this gentleman, who's Cioli and his partner, Cohen, whoever it is, aren't they a little bit like the piano players in a whorehouse? They're playing, and they don't know what's going on upstairs, and Cioli and his partner are saying, we don't know what's going on. It's, maybe these Yale Law students, but it's not our responsibility. We put it up, we set up the rockets, but where they fall, it's none of our business.
Well, to be clear, it's not that they say, in this case, we don't know what's going on. And the law makes very clear here that, first of all, Congress has spoken and said we do want to change the standard over that which we impose on newspapers. Because in this case, what's different from a newspaper, or what's different from, I'm not sure about your whorehouse example, but let's take the newspaper example, perhaps a little bit more relevant to the free speech context, is that what we're doing is creating a space not for the New York Times to speak, what we're doing, or to run ads. What we're doing is creating a space for you and me to post something on Wikipedia. And so the goal here...
Wikipedia didn't exist in 1996. They did speak, but they spoke in a time in which the internet was as new in geologic time as some kind of Neolithic period for humanity, right?
Well,
it's a very different period, 10, 12 years ago.
I think you're absolutely right that the state of the law in this area is still evolving, and the way courts are interpreting it are still evolving.
There we go.
And that, we absolutely agree about that. Violent agreement. That the law is evolving in this area, the way courts are responding, which is why, for example, courts are requiring these websites, for example, to turn over information that they may possess, even if under the statute that Congress has enacted, the website service provider can't be liable for the speech that's going on there.
Well,
but I think that that said, that even though we're 12 years beyond this, and yes, you're right, and there are people and very fine scholars who are talking about whether or not we should have a slightly different standard, whether the law should be changed in order to require, for example, a takedown provision. But we've always given great solicitude toward anything that has to do with speech, and that's where it's different from the piano player in the whorehouse. Is here we're talking about free speech. Here we're talking about not allowing any forces to cause, including private forces, to create an incentive to restrain the speech that people make. Wikipedia would never have come into being without this rule if they had had to police the content that was going on their site. And to be clear, let me just say that if you are policing heavily, if you're writing the content, editing the content, involved in it, then you're just like the newspaper.
Not clear. Not clear yet. I mean, that's not clear on the law. Also, there are lots of intermediate steps that one can take between what we have now and what you call policing, right? There are a lot of intermediate sort of micro-policing or baby policing kinds of steps that can take place that actually end up making speech more free. Let me tell you about a different kind of censorship, a different kind of private censorship. One of the women in this lawsuit has left law school, is taking this semester off because she feels so threatened, so down on herself, so horrible that she can't go to class. She didn't even want to show her face at law school anymore. That's a kind of life censorship. I'm not trying to ring an alarm bell. I'm trying to ring a reality bell that suggests that there are nuances in questions like this, which I think you appreciate very fully. And there are also alternatives to sort of the screaming bloody murder, everything that is not what is today is censorship kind of alarm, which is not the only alternative that exists, right? The alternative to the status quo is not Stalin. Right? That's not the case. So there are a number of intermediate steps, and what's a very interesting and perverse set of outcomes right now with respect to the law. Because right now, NBC can send, because of the protection for copyright, NBC can send one letter to YouTube and get 50,000 videos removed. Yeah. In fact, that law has been so impactful that Google just invented a technology automatically to detect those videos which might be copyright protected. But if your kid sister or your daughter is filmed at a party on a digital camera phone kissing a boy or drinking a beer or something like that, and that video is posted to YouTube, legally, she might be out of luck. That is a perverse set of outcomes, where we protect universal, but not the private person.
I want to ask you about the New York Times, to which you referred. As was pointed out, if any of this stuff was in the New York Times would be responsible for it. So what do we have a rule where you have more responsibility imposed upon the responsible speakers in this society and lesser rules on the lesser responsibility? Does that make any sense? After all, the Times is competing with all these. These people are driving the Times out of business, but the Times doesn't have the same rights that they do.
So there's.
I think the New York Times will win this one.
I would agree. I'm not too worried about the New York Times in this case. The reason that this law was enacted was precisely in order to create a multiplicity of speakers, because in a world in which you had so few speakers, the New York Times, a few centralized broadcasters that were controlling access to communication, the belief was we want to let many flowers bloom, let lots of people create avenues for people to speak on the net. And so hence Congress, and you're right, this is many years ago, said we want to reduce the risk of liability against these small operators, not people like the New York Times who have and have had great lawyers who are working with them to defend them, but people who have no legal budget in order to defend them against potentially repeated lawsuits for everything from invasion of privacy to defamation to all manner of suits that could cripple these service providers from offering us, you, me, and you, avenues for speech.
We've come to an end. Should the Yale Law students lose and the web win, or vice versa?
If the Yale Law students win, the web wins.
Oh, the Yale Law School. Oh, thank you very much for
coming
by. Can I ask you the same question?
I agree in the case here that both of them win, but I think what's at issue here is not changing the law. What's at issue here is the legal profession who are taking a look at the websites about these students ought to get a reality grip and say these are wonderful women, and we're not going to read what the Ayatollah of rock and roll has to say about them. Instead, we're going to use ReputationDefender to save ourselves from the net. Not all the solutions are legal, and the web will flourish, and Yale Law School will still stand.
Thank you very much for coming by, Beth. And thank you for coming by, and come by next week and learn more about the digital age. For the digital age, I am James Goodale. Good night.